Boss, extend behind. Save any base. Send that.
Appeal case number 8/2025, that is Uganda versus Colonel Alitali Dr. DR BESIGYE, Haji Obed Butale, and Captain Ola.
May it please your worship. Richard Lili Kumbuka, Chief State Attorney, for prosecution. All accused persons are in court. For accused senior counsel matters who have introduced the defense.
Please, Your Honor, my name is Kangaroo, Senior Counsel, leading the defense, together with Elias Lukwabo, FK Mpanga, Katumba Apollo, Proscopia Kunihira, Sekajo Abubakar.
The name is?
Sekajo. I'm pronouncing with a Kenyan accent. Aaron Chisa, Farouk Kamleger, Bayan Turinawe, Kintu Michael, Kwagara Isaac, Katuswa Tobias. That is for the first and second accused. And for the third, Mr. Simon Subuga.
May it please your worship. This matter is coming up today for further mention. However, we wish to make an amendment in the charge sheet.
Please, your worship. We are positive of any step being taken by the state before we make our application, which is outstanding since the last time we were here. And it's a command of the Constitution, it's a command of the PCA about the next step in any of the proceedings before you after the expiration of the sixth, the mandatory remand. So we wanted to proceed with our application, your worship, before any other step is taken.
Proceed with the
Most
application.
of that, your worship. Your worship, we pray that you will be pleased to release A1 and A2 on bail in accordance with the provisions of Article 23 of the Constitution. My Lord, your worship, we Clause 6 of Article 23 C, where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such conditions as the court considers reasonable. The operative word here, Your Worship, is shall be released on bail. That what gives this honorable court authority and mandate to invoke these powers in these accused persons on bail. So, Your Worship, from the record, the accused persons have been on remand since the 20th day of November 2024, well beyond the mandatory period provided for under Article 23, Clause 6, Paragraph C. This particular provision is reinforced by Section 76 of the Magistrates Courts Act, which reads as follows, if it may please you, Your Worship. If an accused person has been remanded in custody before his or her trial commences, in respect of an offense punishable by death, for a continuous period exceeding 180 days. B, in respect of any other offense, for a continuous period exceeding 60 days. The magistrate, before whom the accused person first appears after the expiration of the relevant period, shall be released, the magistrate, before whom the person first appears after the expiration of the relevant period, shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in Section 75, unless, one, he or she has, prior to the expiration of that period, been committed to the High Court for trial. Excuse me. Now, Your Worship, from the record, the accused persons have spent over 180 days. That's a fact which is not controverted. And it's also well canvassed in the affidavit of Koindihira Roscovia, which we filed on record, to bring out the history of this matter and the chronology of the events, right from the time the accused persons were kidnapped from Nairobi on 16th of November and taken through the processes before the General Court Martial on the 20th day of the same month, November 2024, and remanded to Zira, where they have been languishing up to the present moment. All those particulars, those facts are borne out in that affidavit, are brought out in that affidavit, which is not rebutted in any way or controverted. Your Worship, on record, on the 31st day of January, the Supreme Court directed the General Court Martial to cease any trial of civilian cases, and that all those matters be transferred to the ordinary court, the conventional courts, the courts of judicature. And that is the genesis of this matter. And that's the reason we are here. So that is in the chain of the events right from the time of kidnap to formal charging or indictment, and then subsequently remand, and up to the present moment. So now, Your Worship, here, there are two things we need to emphasize here. After blocking 180 days on remand, two things here are fundamental. Number one, this magistrate court cannot take any other step save for the handling the proceedings relating to the release of the accused person. No any other step. This honorable court cannot in any way proceed with issues to do with the amendment of the charge sheet or any other action be taken except to issue an order of release. On such conditions, court may deem appropriate. That is number one. The second one is have they been committed before the expiration of the 180 days? The answer is no. And this is the spirit and letter of section 76, paragraph B1. Unless he or she has, prior to the expiration of that period, been committed to the High Court for trial. Prior to the committal. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't constitute the jurisdiction of this honorable court from going ahead with mandatory. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of the law. We would like to ask this honorable court, Your Worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was couched this way in section 76. Why this particular provision was couched? To stamp out persecution, impunity. It was intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution were arrived to that fact that the state may exceed what is actually within the limit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit. The reason there was that limit of 180 days, and the court was given those powers that these, once the state has failed to take steps to commit the accused persons within 180 days, first appearance before you as a magistrate. Don't do any other thing. Please just consider releasing the accused persons. And that's what we are asking for Your Worship. This honorable court should make acquiesce of the unaccomplices in the persecution of the accused person by the state. So the only thing that should be done at this stage is to release the accused persons. So in such conditions, we will be moved forward. We do so, Your Worship.
Your Worship, if I may add, just for emphasis, Your Worship, again, Article 23(5)(c), the command of the Constitution, it says shall, therefore does away with the ordinary bail application, which is made that allows for a discretion. So it is a constitutional command. What the court ought to satisfy itself is that the offense is triable only by the High Court, and that the persons who is the applicant have been on remand for more than 180 days before commitment. So I join issue with my senior colleague, Mr. Lukwago, that the committee per se does not take back time to nullify the 180 days. The 180 days are a constant. Two, Your Worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made.
Repeat that.
I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application is made. And mindful of the decision of the Supreme Court directed a transfer of the fines. What I'm trying to say, Your Worship, is that the process from the court-martial to this court is continuous. There is no break so that the proceedings before the Court of Appeal, or the court-martial, are not taken into consideration. So when we speak to the 180 days, Your Worship, the court must take into consideration the date of remand by the General Court Martial, because it is also a court under the Constitution. So that article, Your Worship, again for emphasis, says in case a person has been remanded in custody. It doesn't say, it envisages that a remand can be made by any court of law, or any court as established by law, of which the General Court Martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year, and therefore they are not 180 days, does not hold. Court takes into consideration the time when the remand started to run, to count the 180 days. And Your Worship, there is a view that perhaps in matters or offenses tried only by the High Court, the magistrate's court should not grant bail because the matter is tried by the High Court only. Your Worship, in the current constitutional dispensation, the magistrate's court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Tesimana Rosemary, the Honorable Mr. Justice FMS Egonantende, as he then was, Tesimana Rosemary, its criminal revision cause number MSK hyphen 00 hyphen CR hyphen CV hyphen 0013 of 1999. I cite it because it is the current dispensation. Because in that case again, Your Worship, the magistrate had declined to exercise powers and sent the file up for revision on the ground that the matter was tried by the High Court. Your Worship, I beg to read, and I'll avail a copy, what the Honorable Justice Egonantende said. My Lord, it is Your Worship, it's the highlight at page 13. So before I take leave of this case, I must say that courts cannot escape the blame for this unhappy set of affairs in the criminal justice system, which has no remorse for caging up people in penal institutions for unjustifiable periods of time. It appears that magistrates' courts to which accused persons are first produced before committal regard themselves as no more than, should not regard themselves as no more than assembly line or conveyor belts run by the prosecution. For years on end, the court is content to record endlessly adjournments, etc. But the point that my Lord, the judge said at paragraph 39, that even though a magistrate's court has no jurisdiction to try capital offences, accused persons such charges are brought before it to ensure that, among other things, the accused rights are protected. The courts must be vigilant in doing so by consistently requiring the prosecution to provide information regarding the investigation. What we are pointing out here is that the constitutional command says that once the accused person is emphasizing their rights, once the matter is before it, even for capital offenses, this court cannot feign not to have jurisdiction on ground that the offense is of a capital nature. In Article 23C, therefore, the accused persons contend that they have been on remand by order of the court so established under the Constitution, the GCM, for a period exceeding 180 days. If I count well, Your Worship, today there should be 196 or thereabout. And that the matter which is before this court now is because the accused persons are exercising their right to mandatory bail as commanded by the Constitution. The onus of the court is, upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and we are told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge in regard to capital offenses. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect to what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In any event, Your Worship, the practice directions of the principal judge and even Chief Justice cannot override the express provisions of the Constitution. We just wish to remind the court, and we are aware that the court is already aware, that the Constitution is the supreme law of the land. Your Worship, Article 2 of the Constitution is clear. Under the subheading Supremacy of the Constitution, states that the Constitution is the supreme law of Uganda and shall have binding force on all authorities and persons throughout Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions we pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Lukwago, Elias, Senior Counsel referred to. We reiterate the prayer that 180 days have elapsed, and as the defense, we shall happily receive the conditions for the mandatory bail, because it is a command that it must be granted.
One of my colleagues will submit an authority. After me, then Senior Counsel will close our presentation in this application. But I want to start with or just emphasize the practical matters. The date of remand and custody was 20th November 2024, via General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. The state is aware of this fact because they have said so. In an affidavit before this honorable court, the state, through its detective IP or Dick Benedict, they acknowledge that the respondents, namely the accused, were previously charged before the General Court Martial at Machinde. application was filed on 5th March 2025, and it is the application for accessing the court records. Yes, the telephone particulars, which your honor is on this honorable court's record.
I think your watch maybe just to interject a bit. Allow me to.
I have not said the word and you're panicking.
Just speak.
Yes, you can't stop me before I say the thing. Relax.
I hope you don't commit another one.
No, it's fine. Don't
So
extend.
what I'm saying is that the document which Maran's brother is referring to has not been actually done. And therefore, it cannot form part of the record. We cannot preempt a document in an application which has not been had and you use it as evidence in your application.
Let him finish his submission so we can make a decision.
Your honor, before I was rudely interrupted by the representative of the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001 of 2025, in
Number?
which the
Number?
number 01 of 2025, in which the state made reliance to the affidavit of Detective AIP Odiek Benedict, who saw that he's aware not only that the accused were charged before the General Court Martial, but that he's also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your Honor, the plea for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial and detention is not too lengthy. Your duty as this honorable court is partly adumbrated by Article 20 of the Constitution. Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is the effect that this court, the office of the Director of Public Prosecution, and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of BESIGYE, Obied, and Dennis. It should not be seen as to frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it behoves you as the judicial officer presiding over this matter under that article to rein in the state and and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months should be seen as inconsequential to the extent of that. And I say this in anticipation of some speech that may come after here relating to some practice directions which are in fact a challenge of the are being challenged before the Constitutional Court. But even those guidelines themselves acknowledge that the Constitution comes first. At this juncture, my learned brother who wanted to give us an authority should give this, then our closure will come through.
Most obliged, Your Worship. Your Worship, for purposes of record, I am to know. Your Worship, I want to join issue with my learned brothers who have submitted on the powers of this court to grant accused persons mandatory leave, but only to add an authority for when court takes a view that the authority that was submitted is of an earlier date. Your Worship, I have much of that. For if court takes a view that the authority that was submitted is of an earlier date, Your Worship, formally in 2022, the Honorable Justice Biaruhanga Jesse, sitting at Masindi in the High Court, in Nyangoma Flavia versus Uganda, Nyangoma Flavia versus Uganda, in criminal application number 7 of 2022, at page 3, paragraph 4, I had the opportunity to say this, and I will quote in verbatim. I have perused the lower court file copies of the lower court copies of the remand warrants and the applicants and 7 others. The remand warrants are to the effect that the accused persons were remanded first in prison on 12 November 2021, save for Kato Francis, A8, who was released on bail on account of being a juvenile. Since 12 November 2021, when the applicant and the 7 others were first remanded to prison, more than 180 days passed before the committal to the High Court. It follows, therefore, that neither the magistrate's court nor the court that has neither the magistrate's court nor this court has any discretion not to grant them bail. It was a violation of Article 23, Clause 6 subclause C of the Constitution as amended, for the magistrate before whom the accused persons first appeared after the expiration of the 180 days remand period to decline or refuse to release the accused persons on bail, for he or she had no discretion to do so. Your Worship, if I may add, is that such a decision of the High Court has a binding authority nature on this specific court. Your Worship, the Honorable Justice Jesse Yarohanga took a view that the magistrate does not have discretion to deny an accused person who has appeared before him or her after the lapse of 180 days for avoidance of doubt, Your Worship. The accused persons were charged with murder, which is a capital offense and only triable by the High Court. Your Worship, my comfort in that authority is to the extent that this decision is of similar nature as the case we are faced with today. And therefore, I reiterate the area of prayers of my learned brothers that the accused persons are entitled to be released, and keyword, entitled to be released on mandatory bail by this court. And this court has no discretion to deny such an application. Much obliged, Your Worship.
Please, Your Honor, I'll be brief, but before I canvass my 2 points, I just want to tell my learned friend, the prosecutor, that it is unfortunate that he would refer to the previous incarceration of Aaron, whether in jest, knowing very well that it was before a lay court, because he said that he may once again be acquitted. It is not a fair thing to do, and it cannot be taken in jest.
Just
I'm requesting
Once a moment.
Just one. Excuse me, please make way so that they can set someone.
Outside for fresh air.
Please create someone. Can we have order in court?
Yes, I was just expressing regret that my friend would, my learned friend would joke with liberty of a colleague taken away illegally, as the Supreme Court found. But having said that, I want to commend my team. They have demonstrated to Your Honor the law on bail and the fact that the court has no discretion whatsoever. But we also want to refer you to one more case from the Supreme Court in the Foundation for Human Rights Initiative versus the Attorney General. And the Solicitor General, Constitutional Appeal number 3 of 2009.
Just
Katurebe CJ,
repeat the case.
Foundation for Human Rights Initiative versus the AG. And SC, Constitutional Appeal number 3 of 2009. The decision is by Katurebe CJ, as he then was. He held that when an accused person applies for bail, the court retains the discretion whether or not to grant bail to the accused person, which discretion has to be exercised judicially. But now comes the most important. The only time when the court has no discretion is when a person has been on remand for the period stipulated in Article 23(6)(b) or 23(6)(c). In those situations, the court shall grant bail. I suppose the court retains the power to determine the terms of the bail. In other words, this is a Supreme Court decision, and this honorable court is obliged to follow not just the High Court, but the Apex Court decision. Now my 2 points. I want to refer you to the obvious 26 of the Constitution of Uganda, which clearly states that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with values, norms, and aspirations of the people. In other words, the framers of the Constitution and the people of Uganda put the trust in judiciary to adjudicate on these matters. I am therefore urging Your Honor, in exercising your judicial power and in giving the ruling in this bail application, to abide by the values of constitutionalism and the rule of law, and in the name of the people of Uganda, grant our clients bail. My learned friend will be submitting on the 3rd on A3, but they have a similar history of detention, not exact the same period, but anybody who has finished more than 180 days, you are obliged to release them pending their committal. I'm also reminding the court of the obvious that the scales of justice must balance, and in Article 21, equality and freedom from discrimination, we come before you as parties with equality of arms. Therefore, the prosecution and the defense are equal before you. None is superior. And none should come with the assumption that they carry more weight. Therefore, it is your duty to demonstrate, because justice must not only be done, but must be seen to be done, that the scales of justice are balancing, and that you are availing all the parties, and in this case, A1 to A3, the due protection of law. And the law on bail is for their protection. So we urge you to exercise your discretion to give them bail on such terms as you find fit to enable these proceedings to continue when they are free, because they've stayed in custody for the maximum period allowed by law. I yield to my colleague, Spura, for the A3.
Worship. First, I join issue with the submissions of Senior Counsel Justin Kwabo, Frederick Mpanga, Martha Karua, Aaron Chiza, and Brian. We contend that Captain Ola Dennis has been on remand exceeding the mandatory 180 days. Your Worship, Section 76 communicates to you and says that what happens when they present Ola to you after the elapse of the 180 days. You're only left with one option: to release Captain Ola. These are the situations where you cannot release Ola. If he has been committed to the High Court, Your Worship, Ola has not yet been committed. Or if it is in the public interest that Ola must not be released, Your Worship, there isn't any evidence that Ola is harmful to the public. Your Worship, then back to Article 126. Exercise of judicial power, which is derived from the people. Clause 2, in adjudicating cases of both civil and criminal nature, Your Worship, these cases of criminal nature, the courts shall subject the law applying the following principles: that justice shall be done to all irrespective of their social or economic status. My Lord, Your Worship, Ola is a soldier. We pray that he also enjoys the liberty that is granted, couched in mandatory terms under Section 23(6)(c) of the Constitution. It also further says that justice shall not be delayed. The framers of this Constitution were privy to the fact that criminal prosecution is delayed. That's why they came out with a position that when an accused person is remanded exceeding 180 days, your choice is limited. And Your Worship, I'm appealing and praying for your choice. Maybe push me to the conditions that may be reasonable to grant Ola bail. Ola is a family man. He's a father. Actually, he has children who have to go back to school. He's not sure that they'll go back to school because their father is here. That is Ola. Any other application to keep Ola in lawful custody, we submit that it is very absurd. With that, Your Worship, we join issue with the earlier submissions of the Senior Counsel.
Accused persons have a right to apply for revision in the High Court. Section 48 gives the High Court the power to call for the proceedings of the lower court to examine them, and it is at that point that the lower court can forward the file for revision purposes. This court cannot hold the criminal proceedings to await the revision proceedings. The court will proceed with the proceedings.
Maybe Doctor will use that one. You can move it and then you hold it.
Your Worship, once again I seek your indulgence as I did previously. Because as has been severally cited, this is a very serious case against us that may lead to our death. Your Worship, this is not the first time I am being charged with treason. This is in fact the third time the DPP has charged me with treason. Last time we were in this court in 2016. And we stayed in this court for 5 years before they withdrew that charge of treason in 2016. But before that, apart from the other charges of treason, they have charged me with rape, which went to trial, in which the DPP's chief witness, the director of criminal investigations, admitted under oath in the High Court that she had falsified police documents in order to get at me. Under oath. I have also been charged by the same DPP with terrorism, with the illegal possession of guns, all of which charges ended in nothing except my suffering. In fact, before I was brought and charged here with the treason in 2016, I was charged with the same offense in Karamoja, in Moroto, before the DPP realized that he had presented the case in the wrong court. I had spent time in Karamoja, in Moroto prison. So you worship. When I seek your indulgence to pursue our freedom, it's against this background that I seem to be trapped in a country where the prosecutor does everything that leads to my suffering and the suffering of my family. So that's why when we applied for mandatory bail, having spent 6 months, more than 6 months in prison without a committal, it is because we know that they will try to do everything to keep us locked up, tortured, without the legal basis to do so. So, I'm not a lawyer. My lawyers, I believe, have done a good job in seeking our freedom, considering that it's more than 180 days since we were remanded. They have sought for leave. I think they have asked the court to stay these matters so that we seek a revision of what has been decided. That seems not to have gained your favor. Your worship, it's under those kind of circumstances, prioritizing our freedom and the suffering of our families. But I would like to ask my lawyers, prioritize what needs to be done to seek our freedom. All these charges I have faced, I have never, ever failed to appear in the court for trial. Never for mention, if it is mentioned. Only that it keeps me in the courts rather than doing my my door. So you worship, I pray to you this afternoon, is that in the circumstances, I am asking my lawyers to prioritize our freedom, to go and seek that revision, to go and seek that day where it should be. Please, you can get any reliefs from here. I am in prison, and anybody who thinks that being in prison is a cup of tea should try being there. We don't want to stay in prison much longer, but we are in prison. And we will stay in prison as all this is going on. It's our post in our lives to stay in prison. But allow us to worship that we prioritize what is priority to us, which is seeking, as the law provides, that we get relief from the prosecutor's arm and stay in our homes as he does whatever he wants to do. It would be extremely, I think, unfair for me to continue with him, doing what is good for him, without doing what is good for me under the law. So, worship. I ask my legal team to proceed now and do the needful, and that you give us time to come back, pay attention to what is doing.
On behalf of there's another
Just keep it brief.
Your Worship, thank you so much for the opportunity.
How do you speak louder?
I don't want to go deep into what I'm going to speak, but I'm not diverting from what my court has stated. To be specific, today I've made 592 days remand. And this has got to do with my rights. And what we are trying to seek here is simply, under the Constitution, it is on that background, therefore, I have given a strict instruction to my lawyer to strictly pursue the review of this decision on mandatory bail. It is after that that I think other procedures can continue. That's all I request.
Your Honor, with those instructions from our client, on behalf of the team, we seek to withdraw to go and prepare the necessary applications. Thank you.
Worship, we are constrained to abide by the instructions of our client, regrettably, so we ask you to allow us to leave because it would appear we no longer have instructions to proceed.
Proceed. Proceed.
May it please your worship. We wish to make an application for amendment of the charge sheet. Your worship, we filed a copy of the amendment, which is dated the 29th day of 2025. 29th day of 2025. We actually served the offense with that copy. We had filed one on this, but it had some typo issues, so we made an amendment for which we served the offense while we were in court. But also, this amendment, the one with the correction, was uploaded to Netflix as well. So in the circumstances, we pray that court grants this application to have the charge sheet amended and read to the applicants, since they are not represented for now.
The amended charges should be read to the accused person.
That's the one that the copy, the one which I did the 29th of May.
Let me look at it. The amended charges should be read to the accused person. Listen to the amended charges.
Colonel retired Dr. Kiza Besigye, Kifefe. You are a male adult, Ugandan, a retired UPDF officer. You are 67 years of age. You are resident of Kasanga Town Council, that is Nagabu Sub-County, Nansana Municipality, Wakiso District. Haj Obed Butale. You are male adult, Ugandan, 65 years of age. You are resident of Mutundwe Parish, Makindye Sabagabo Sub-County, Usiro County, Wakiso District. Captain Dennis Olal, you male adult, Ugandan, 48 years of age. You are a UPD officer attached to Amari Brigade. You are charged with, both of you are charged with first count, that is treason, contra section 20 subsection 1, C of the Penal Code Act, Cap 128. Particulars allege that you, Colonel retired Dr. Kiza Besigye Kifefe, Haji Obeidi Butale, Captain Dennis Olal, and others still at large, between the year 2023 and November 2024, at various places and countries, including Geneva, that is Switzerland, Athens, Greece, Nairobi, in Kenya, Kampala, Uganda. You contravened a plot to act or matter by force of arms to overturn the government of Uganda as by law established and expressed or declared such a plot, act or matter by utterances and overt acts. A. You cannot, Dr. Kizza Besigye, Kifefe, you traveled to Geneva, Switzerland, and attended a meeting on the 29th day of October 2023 with others, where you and others discussed a plot to overthrow the government of Uganda by force of arms. B. Colonel retired Dr. Kizza Besigye, Kifefe, you traveled to Geneva, Switzerland, and attended a meeting on the 24th January 2024 with others, where you and others discussed a plot to overturn the government of Uganda by force of arms. C. That you, Dr. Colonel retired Dr. Kizza Besigye, Kifefe, you traveled to Geneva, Switzerland, and attended a meeting on the 14th day of June 2024 with others, where you and others discussed a plot to overturn the government of Uganda by force of arms. D. That you, Colonel retired Dr. Kizza Besigye, Kifefe, you traveled to Athens, Greece, and attended a meeting on the 29th of September 2024 with others, where you and others discussed a plot to overturn the government of Uganda by force of arms. E. Colonel retired Dr. Kizza Besigye, Kifefe, and Haji Abed Lutale, you traveled to Nairobi and attended a meeting on the 16th day of November 2024 with others, where you and others discussed a plot to overturn the government of Uganda by force of arms. F. That between 14th day of June 2024 and 24th of July 2024, you Colonel retired Dr. Kizza Besigye, Kifefe, you solicited for and received $5,000 and applied the funds to facilitate a group of 36 individuals to travel from Uganda to Kisumu, Kenya, in order to attend and receive training in furtherance of the plot to overturn the government of Uganda by force of arms. G. That between 29th October 2023 and the 16th November 2024, you Colonel retired Dr. Kizza Besigye, Kifefe, Captain Dennis Olal, and others made various utterances on the WhatsApp social media platform, where you discussed and expressed your intentions to overturn the government of Uganda by force of arms. Count 2. This is in respect of Dr. Besigye. This is misprision of treason. This is contrary to Section 25 of the Penal Code Act.
I pray that the person asked about count 1 before we proceed to count 2.
Plea not taken for lack of jurisdiction on count 1. Plea not taken for lack of jurisdiction. Plea not taken for lack of jurisdiction on count 1.
That you are not asked whether you committed these offenses or not, because this court doesn't have the jurisdiction to try you. This count 2, I said already that in respect of Colonel, you are charged with misprision of treason, contrary to Section 25 of the Penal Code Act, Cap 128. Particulars of this offense are that you, Colonel retired Dr. Kizza Besigye, Kifefe, and the others you at large.
But the lady all understanding? Maybe that
They do. They are not to be.
We proceed? Proceed. Proceed.
Colonel retired Dr. Kizza Besigye, Kifefe, and others you at large between the year 2023 and November 2024 at various places, including Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, Kampala in Uganda, knowingly that another person, to wit Joel Wakwaima and Frank Hihehere Atukunda, intended to commit treason, you did not give information thereof with all reasonable dispatch to the minister, an administrative officer, a magistrate, or an officer in charge of police station, in charge of a police station, or use all reasonable endeavors to prevent the commission of that treason.
Plea not second for lack of jurisdiction.
This is in respect of Dr. Haj Obeid Utale and the Captain Olal. You are charged also with misprision of treason. This is contrary to Section 25 of the Penal Code Act, Cap 128. Police has alleged that you, Haj Obeid Utale, Captain Dennis Olal, and others still at large, between the year 2023 and November 2024, at various places, including Nairobi in Kenya and Kampala in Uganda, you knowingly that another person, to wit Colonel retired Dr. Kizza Besigye Kifefe, intended to commit treason, you did not give this information thereof with all reasonable dispatch to the minister, or, an administrative officer, a magistrate, or an officer in charge of a police station, or use of all reasonable endeavors to prevent the commission of the treason.
Plea not taken for lack of jurisdiction.
Also blessed. Your Worship, we are ready to commit the accused persons as part of the investigations are complete. We filed the indictment and summary of the case for next week, but it had a typo error, and we therefore filed another one today, which is dated 29th of May, 2025.
Yes, sir.
And we also served that on to defense counsel for first applicant, second applicant, and the third applicant. And a copy of the same is on record. It is there, it is on that background, Your Worship, that we invite this court to proceed under Section 168 of the Magistrates Court Act.
Please, as you record, be mindful not to.
We invite court, Your Worship, as under Section 168 of the Magistrates Court Act, Cap 19, to have the accused persons, the indictment and summary of offense, to the case read to the accused persons and have them committed to the High Court for trial. So,
Where is the indictment and summary?
there's a copy, we filed a copy, but I can patch you with another copy here, dated 29.
Yes. Yes.
Yes, Your Worship, once again, I don't know whether you intend to proceed, whether it's commitment or whatever the prosecution wants to be done in the charges that have been read for us when we are not represented.
Yes,
you want
yes,
to
I want to say something. Your Worship, first of all, this matter, initially, the lawyers have been in court and have been on record. and it is on record that the accused person is represented. When this matter came up, for ruling on whether or not this court would refer this matter for revision on its own initiative, and the court said no, the accused person instructed his lawyers to move out of court, which is not the usual practice in how court conducts its business. It was not fatal for the accused person and his lawyers to wait and listen to the prosecution before they would make a protest move out of court, which we as prosecution condemn. And this has not been the first time. Even last time, counsel for applicant moved out of court. And indeed, the accused person denied his lawyer, yet they had been put on record. And after ruling, the accused person said he never gave them instruction to proceed any further, and the lawyers moved out. The process.
Just keep it brief.
No, I'm finishing up. The process that we are undergoing, yes, the accused person requires, he has the right of legal representation right from the start up to the end of the criminal matter. But the process that we are undergoing right now is not fatal. Is not fatal to proceed without the lawyers who have actually deliberately moved out of court. Because that is an attempt to dictate on what court has to do, on what prosecution has to do, and I think we shall go nowhere. The process of having the charges read and a committal process as per section 168, in fact, the DPP is not supposed to come and present the committal papers physically. The law says we are supposed to file, and once we file them, the accused person, it is the duty of court to read out the committal papers to the accused person. It is not a prerequisite for us to come and say we are bringing them. So prosecution or DPP, office of the DPP, will have discharged its duty by merely filing. This is what we did. We filed these papers, committal papers, on economists, where the accused lawyers are linked. But let me read this section, Your Worship, just for everyone to understand. This is section 168 of the Magistrates Court Act, Cap 19. It says, where a person is charged in a magistrate's court with an offense to be tried by the High Court, the Director of Public Prosecution shall file in the magistrate's court an indictment and a summary of the case, signed by him or her or by an officer authorized by him or her in that behalf, acting in accordance with his or her general or special instruction. 168(2). The summary of the case referred to in subsection 1 shall contain such particulars as are necessary to give the accused person reasonable information as to the nature of the offense with which he or she is charged. 3. Just allow me, this is very important. When a person charged with an offense to be tried by the High Court appears before a magistrate and the Director of Public Prosecution has complied with the subsection 1 of the Magistrates Court, which we have complied with because we actually filed the indictment and summary of the case. We have complied with that. But now the section says if the DPP has complied with that, what is next? The magistrate under 3A give an accused person a copy of the indictment together with a summary of the case, which we have given on equities. Because in equities, by virtue of that, we have. So, and then B, read out the indictment and summary of the case to the accused person with the nature of the accusation against him or her in the language he or she understands, and inform him or her that he or she is not required to plead to the indictment. Your Worship, this provision, even without doing this formality, as long as we file, the DPP has complied with the law under Section 168 of the Magistrates Court Act. Therefore, the proceedings right now are regular. They are legal. Even without the appeals being presented, because the lawyers will do nothing in this process. It is self-explanatory. They have no input, apart from being informed. But again, this scenario is again different, that the lawyers knew of this, but they have chosen to move out of court. So you are in order, Your Worship, to proceed to the committee.
Let court make its ruling.
If I reply,
Okay, reply.
Your Worship, you know, again, if it was about condemnation, having said what I have said about the DPP over Uganda versus me,
Just keep it summarized.
yes, you not only need condemnation, you need to be in prison. People who falsify evidence to incriminate a law-abiding citizen cannot be served by only condemnation. So, Your Worship, our lawyers did not go out in protest. They went out with our instructions, as I pointed out, to do what was most urgent in the circumstances. Because they have been following this matter here. Now, unless you suggest that court or DPP will also guide me on which lawyers apply on which matter concerning this case, I should then be given the liberty, just like my colleagues, I believe, to choose which lawyers to attend to which at what time. And all I'm saying is, we are the ones in prison. So we are not going to run out. We are saying, give us time. This, we shall get lawyers to deal with this matter when you fix it. But to proceed as if, because we have asked our lawyers to pay attention to one thing, we therefore forfeit our right to be represented, would be unfair, and I request that you don't proceed with that. Because the fair hearing is the process of the whole case. And as I have emphasized over and over again, it's a case that can end in death. So what is the hurry in not allowing us the latitude to be represented by those we want to be represented by and pursue what is urgent by those who need to pursue what is urgent? I request your worship that you give us another day when this matter can proceed with our lawyers. And if it is not entertained, maybe you entertain me to seek a constitutional reference to find out whether indeed that right I have to be represented at all these stages should not be respected. Thank you.
This is our ruling. accused lawyers have been in court and they informed court that they have been instructed to withdraw from court. The accused lawyers, on their own volition, chose to leave court without being ordered to move out of court. The accused also informed court that he's giving his lawyers instructions to go and take the necessary steps for his personal liberty. I find that the accused in this case has waived his constitutional right to legal representation in his proceedings, and this court cannot be faulted for this. The committal proceedings should proceed as they are legal and proper. The prayer for an adjournment is denied. The accused A1 can also not seek a constitutional reference where he has chosen to waive the right to legal representation. We proceed with the committal proceedings.
Worship.
Yes, Your Worship, we have punched court with the copy of
Worship. Whether I have waived or not waived my rights is a matter that I would want to be determined, whether by assigning lawyers a certain duty that is more urgent than another tantamounts to waiving my right under the Constitution to be represented. Our rights, all of us, to be represented is a matter that I think this court should give me the opportunity to exploit under Article 137 of the Constitution.
Our court has made its decision on the constitutional reference. Please proceed with the committee proceedings.
But the court has no...
Colonel, let's court proceed. Your lawyers can seek legal redress.
They are my lawyers. I'm here myself.
You will inform them and they can seek legal redress. Please proceed.
Yes, Your Worship, we have punched court with the copy of the indictment and summary of the case, dated 29th of May 2025. We ask the court, Your Worship, to have the guy's name and the summary read to the accused persons, and then have them committed to the High Court thereafter.
Read for them the indictment and summary of the case.
Standing out to another kangaroo court. I think you people should just...
Can we have order in court?
Order, please.
Can we have order in court? Can we have order in court? Can we have order in court? Proceed with the committee proceedings.
A moment for one. These courts are being made a joke. It's not working.
Dr. DR BESIGYE, Haji Rutale and Captain Dennis Olal, another three at large. Please come to one. This is the summary. That the Director of Public Prosecutions shall, at the trial, adduce evidence to prove the following facts. 1. That Colonel, retired Dr. BESIGYE, A1, is a retired Ugandan People's Defense Forces, that is UPDF, officer having served the army in various senior positions previously, that you also a found member of the Forum of Democratic Change, FDC, a political party having served as its president for several years. You also a former multiple presidential candidate in Uganda. 2, that Dr. BESIGYE, you have been fiercely opposed to the current national resistance movement government over time. You have openly expressed your desire to change the leadership of the country through violent means such as the infamous walk-to-work, political protests, and defiance campaign. 3, that you had Abedul Chale, A2. You are a member of the People Front for Freedom, which is a breakaway group from FDC and commonly known as the FDC Katonga Group. At the time of arrest, you were a personal assistant to Dr. BESIGYE. That you, Captain Dele Solal, A3, you are UPDF officer attached to the Amale Brigade. 5, that Andrew Wilson, herein referred to as AW, is a proprietor of a private security company that deals in various security-related services, including the sale of arms, investigations, and tactical training on firearms, among others, since 2003. 6, that sometime in the year 2021, AW was contacted by Mr. Joel Wakaima, herein after referred to as JW, a Ugandan citizen who was based in Switzerland. JW informed AW that he needed the company to provide firearms, weapons, and training to some Ugandans, both domestic and in the diaspora, to overturn the government of Uganda by force of arms. JW requested AW to execute the work for him. 7, that upon listening to the details of the request of JW, AW realized that it was criminal and decided to search for Ugandans authorities to report the matter. AW was provided with the contacts of the commander of the Ugandan contingent of AMISON, and senior UPDF officer who at the time was based in Somalia. AW narrated to the UPDF officer that JW was planning to do and inquired that to do. Full stop, the UPDF officer requested AW to become a government spy and to continue engaging JW in order to establish the details of the plot to overturn the government of Uganda, which AW accepted. AW was introduced to intelligence officer at Chieftaincy of Military Intelligence, CMI, under whose supervision he continued to work and to who he regularly reported his activities. 8, that AW then continued to engage JW over the next 2 years until 2023, when JW introduced AW to Salam Musumba. AW had a conversation with Salam Musumba by Zoom call, and proceedings at this meeting were recorded by AW. During this meeting, Salam Musumba requested for the training of their people in covert communications and intelligence gathering techniques for purpose of spying on the government. 9, that Salam Musumba subsequently requested for a meeting with AW in Brussels, Belgium, where she invited many other people to attend, including Road Mayor of Kampala, Elias Nkwago. Honorable Salam Musumba, Honorable Semuju Nganda, Rebecca Mukaku, and accepted to join the plot to overthrow the government. Mukaku and Charles Romushana. In the discussion at this meeting, AW accepted to join the plot to overturn the government and agreed to be their security and military advisor. The discussions at this meeting were recorded by AW, and the recording shall be relied upon at the trial. 10, that upon building sufficient trust in AW, Salam Musumba requested JW to introduce AW to A1, that's Dr. BESIGYE. This was done, and the two, AW and JW, had an online discussion with Dr. Besigye about the grand plot to overturn the government of Uganda by force of arms. This culminated into the first physical meeting between Dr. Besigye and the AW on 29th day of October 2020 at Geneva, Switzerland. 11. That the first physical meeting was held in Geneva, Switzerland on 29th day of October 2023 and was attended by AJ, Dr. Besigye, Frank AW, Dr. Besigye, that is A1, Frank Kihenere at Kunda, and JW. At this meeting, the group discussed the plot to overturn the government of Uganda by force of arms. A1, that Dr. Besigye requested for military assistance from AW to destabilize Uganda. A1 also requested the AW to train some of his that is Dr. Besigye allies in covert intelligence and paramilitary tactics, which request AW accepted. A1 further requested for counterfeit Ugandan syringe with intent to sink into the economy of Uganda through his collaborators who is stated to be officials in Bank of Uganda as a means of raising finance for Dr. Besigye's objectives and also destabilize the economy. In the same meeting, Dr. Besigye, JW, and Franca requested for reaching poison to poison targeted government officials. 12. That further, in the same meeting, Dr. Besigye provided AW with a list of government security installations and military facilities like Simba Barracks in Mbarara, 2nd Division, Makenke Barracks, Bugembe Barracks, Bugemba Barracks, Bihango Military School, Kachoma Mountain Brigade, Kabalole Gaddafi Military Barracks, in Magamaga, Mayuge District, Marine Division Luzira, Air Force Academy, Nakasongola Engineering College Lugazi, Nakasongola Engineering College Lugazi, Junior Staff College, Dachimaka, Singo Karugutu Training School, Ntoloko Military Intelligence and Security School in Nakasongola District. Makinde Military Barracks, Police School, Bwebaja, and Oliver Tambo, Kaweweta, among others, as targets for attacks that, after agreeing to conduct a training in Kisumu, Kenya, Franka Kihekere at Kunda traveled to Uganda with Dr. Besigye to organize their intended group of people for training. The proceedings of the above meetings were recorded using a covert camera by AW, and the same will be relied upon during the trial. 13. That Dr. Besigye and AW created a strong communication, strong relationship through the social media, including WhatsApp. Dr. Besigye provided AW with his Swiss contact line number +41 77 81 38 990, through which he frequently communicated with AW on mobile line number +19 54, 39, 40, 14, 1. WhatsApp. During the period from their first meeting on the 29th of October 2023 up to 16th November 2024, Dr. Besigye and AW had numerous conversations and exchanged numerous social media messages. Wherein Dr. Besigye discussed with AW details of his intentions and the plot to overturn the government of Uganda by force of arms. Full stop. A forensic extract of the record of their conversation shall be relied upon during the trial. 14. That in about October 2023, A3 was recruited by JW into joining the conspiracy and the plot to overturn the government of Uganda by force of arms. A3 accepted and exchanged various utterances on the WhatsApp social media platform with JW using his phone, where he expressed his support, desire, and intention to overturn the government of Uganda by force of arms. 15. That Dr. Besigye attended another meeting on the 24th of January 2024 in Geneva, Switzerland, which was also attended by AW and JW. At this meeting, Dr. Besigye assured the AW that he was committed to facilitate the training of his people to overturn the government of Uganda by force of arms. Full stop. In this meeting, Dr. Besigye and JW further requested AW to assassinate the president of Uganda using a drone strike. Dr. Besigye undertook to provide AW with the president's movement routine and vulnerable points to facilitate his assassination. In exchange for AW's assistance, Dr. Besigye and JW undertook to grant the Kurdish government company access, Kurdish government company access to Ugandan banking sector, to launder money, permit the use of Uganda's airfields for trafficking illicit goods, including drugs, use Uganda as a safe haven for Kurdish fugitives and general permit the use of Uganda for illicit activities once the plot to overturn the government was successful. 16. That on 14th June 2024, Dr. Besigye attended a meeting with the AW and JW in Geneva, Switzerland. In this meeting, the participants further discussed the plot to overturn the government of Uganda by force of arms. Dr. Besigye requested the AW to arrange for the training of selected groups of people like-minded conspirators from Uganda in Kisumu, Kenya, in intelligence and gathering surveillance operations, espionage techniques, and use of drones to be used in overturning the government of Uganda. In the same meeting, Dr. Besigye and JW repeated their request for AW to supply them with counterfeit Ugandan currency, drones, weapons, and grenades, which they named pineapples, in quotes. Dr. Besigye provided the AW with air stripes, coordinates, 2, 17, 30, 35 inch, N, 32, apostrophe 1, 34, E6G, JH72VH plus 2P 72VF plus 2P, length of stripe 1900 M, 6,233 feet, altitude 5,266 feet, 1,605 meters, M. MSC, this is a bracket, aerodrome D, manage, bracket, close bracket, in DRC for airdropping of weapons. Dr. Besigye further informed the meeting that he intended to use part of the Zambia territory for training and logistics. At the same meeting, AW gave Dr. Besigye US $5,000 to facilitate the movement of the selected Ugandan trainees from Uganda to Kisumu, Kenya for training. 17, that in the same meeting, Dr. Besigye introduced two AW to individuals to wit Simon Lutalondwa and Makoha Samuel as his liaison officers for the planned training in Kisumu, Kenya, as well as additional persons of contacts in case of Dr. Besigye and Dr. Haji Lutale were unavailable, that the recording of the meeting of the 24th July 2024 will be tendered and relied upon during the trial. 18, that during the month of July 2024, AW traveled to...
That is the typical error. It's supposed to be 14th of June.
That during June 2024...
We're going to change it to put it right. It's supposed to be...
18, check 18. And now, back on 17, it's supposed to be as clear as the Chief Sergeant that instead of 24th July 2024, it's supposed to be 14th June 2024. Now we go back to 18. That during the month of July 2024, AW traveled from Athens, Greece, to Kisumu, Kenya, to train the selected group of over 30 Ugandans who had traveled from Uganda and were congregated at Ukweli Pastoral Center, where he met Samuel Makoha in order to avoid law enforcement detection and to conceal the true nature of their mission. The 36 individuals traveled and crossed the border separately and did not travel as a group in accordance with previous agreements with Dr. Besigye and the AW had traveled to facilitate the training of the group, and he was expected to deliver counterfeit Ugandan currency and grenades, which the two parties commonly refer to as pineapples in black, as previously requested by Dr. Besigye and the JW during their meeting in Geneva. 19. However, before the above training could take place, the group of 36, which included Simon Lutalondwa and Samuel Makoha, were arrested by Kenyan authorities before the training could take off and later deported to Uganda. That Dr. Besigye, who had also traveled to Kenya for purpose of attending the same training, disappeared upon receipt of the news of arrest of his accomplices. The group of 36 were handed over to Ugandan authorities together with several exhibits including police carried out criminal investigations, and the group of 36 were later charged with criminal offenses of at Nakawa Chief Magistrate's Court, Nakawa criminal case number CR 27/2024. 20, the number 20, that after the aborted Kisumu training, Dr. Besigye and the AJ agreed and met again on 29th of September 2024 in Athens, Greece. At this meeting, the two discussed an armed attack against Ugandan government military facilities, including the Nakasongola Air Base. Dr. Besigye requested AW to supply him with surface-to-air missile and drones intended to destroy Ugandan aircrafts at Nakasongola Air Base. Dr. Besigye with AW discussed how to attack Nakasongola Air Base with drones in order to destroy governments of Uganda, helicopters, and other military aircrafts within Uganda as one of the ways through which the government of Uganda would be easily overturned. 21. That during the said meeting of the 29th of September 2024, Dr. Besigye and AW agreed as a way forward to hold a meeting in Nairobi, Kenya, where Dr. Besigye would be able to meet their Kurdish/Iraq contacts for AW. Dr. Besigye and AW continued communicating with each other via WhatsApp on mobile lines, plus 41 77 81 38 990 and plus 1954 39 40 141 respectively. The WhatsApp communication chats between Dr. Besigye and AW about convening the Nairobi meeting will be tendered and relied upon in court during the trial. The group agreed to have a follow-up meeting later in Nairobi, Kenya, that the said meeting of the 29th day of September 2024 was recorded secretly by AW and another individual who was AW's agent. The recordings will be tendered and relied upon in court during the trial. 22. That on 16th November 2024, Dr. Besigye Hajirutale, together with AW and his Kurdish contact, attended a meeting of 108 Riverside Apartment, at 108 Riverside Apartment in Nairobi, Kenya, to further discussion the plot of overturn the government of Uganda by force of arms. Full stop. The Nairobi meeting was attended by Dr. Besigye, Dr. Hajirutale, and the AW and his Kurdish contact, who was posing as a representative of the Kurdish government company. At this meeting, Dr. Besigye introduced Hajirutale as his personal assistant and a person who was part of the plot to overturn the government of Uganda. At this meeting, Dr. Besigye repeated his request to be supplied with surface-to-air missile and other weapons to attack the government of Uganda. Weapon to attack helicopters and aircrafts as one of the ways to overturn government of Uganda. Dr. Besigye and Hajirutale also briefed the meeting about their plot to instigate civil disobedience strikes in Uganda, starting with assassination of the President of the Republic of Uganda in March 2025, in order to achieve your objectives. 23. That on the 17th day of November 2024, Dr. Besigye and Hajirutale were handed over to the Ugandan security officers from Defense Intelligence and Security, meaning blackly this, at Malaba border, together with several exhibits which included their mobile phones, 2 pistols, and other items. The two were later charged at the General Court Martial Makinde with offenses under the UPDF Act. By the UPDF stock GCM stock 0440/2024. However, following the decision of the Supreme Court in the case of Attorney General versus Honorable Kabaziguruka Michael and others, the matter was transferred to Uganda Police, which conducted fresh investigations from 12 February 2025. 24th, the accused persons, that is Dr. Besigye and Haji Rutale, were each examined on PF 24, and all of them were found to have a normal mental status. Their medical reports will be tendered and relied upon during the trial. 25. That the police obtained call details, the court's CDRIs, and know your customer, that is black KYC information for Dr. Besigye and Haji Rutale, analyze the communication patterns between the accused persons and developed an analysis report. Full stop. The communication analysis revealed that the accused were constant communication with each other during the relevant periods. The call detail records, that is black CDRs, KYC information and communication analysis report will be tendered and relied upon in court during the trial. 26. That police investigations retrieved immigration codes and the travel history of Dr. Besigye and Haji Rutale, Simon Rondwa, Samuel Makoha, and individuals and others. The records were analyzed and confirmed that the various individuals traveled outside Uganda during the periods of the alleged meetings and trainings, that immigration documents and records shall be tendered in court. 27. That since 2021 and all along, AW was constantly providing updates to his handlers within Uganda's military intelligence. He covertly recorded both on video and audio all relevant meetings with Dr. Besigye and Haji Rutale, JW, and others conspirators, and shared these recordings with the intelligence officers in the same way. He later handed over the electronic gadgets used to make the recordings and the audio, stock video recordings to investigators. These were forensically examined, and the resultant examination reports shall be relied upon at the trial. 28th, that prosecution shall contend that Dr. Besigye, Haji Rutale, and Captain Olal, Makoha Samuel, Simon Rutalondwa, Joel Makohaima, Frank Atukunda, Ahalele knew and were aware that each of them intended to commit treason but did not report it to any authority in Uganda or use reasonable endeavor to prevent the commission of treason. 29. Prosecution shall further contend that all accused persons indicted in this case, indicted in this case, acted with common intent and in concert with each other and are culpable as such. Whereupon, prosecution shall contend that the accused persons do not have any valid defenses to the indictment, and that they should be convicted as indicted. Dated at Kampala, this 29th day of May 2025. Signed by Yakiko Thomas, Director of Public Prosecution.
Accused persons are committed to High Court for trial.
Most of that. Your Worship, we have a defense application number 1. this application number 1, which prosecution filed. And this application was also frustrated through an application for revision, which has never come to pass. In the circumstances, we find this court to adjourn this application to another day. Because we intend to proceed with it.
Which application is that?
It is the Mrs. application number 1 of 2025. Nakawa. Your Worship, in respect to the copies of the accused persons, we served the defense lawyers with a copy of the indictment. We served the defense with the copies of the indictment, and Your Worship, if at all, we can withdraw one copy which we gave court when we proceeded, because we had filed a hard copy. We can give the accused person, or we can run these copies very fast, immediate after. Because we didn't foresee the counsel for accused persons leaving court. We didn't foresee that. Otherwise, we had punched them with the copies of the indictment.
So I see that the judicial officer who was handling the matter then, on that miscellaneous application, held that so he proposed to have this matter adjourned as we wait a decision from High Court. Matter is therefore adjourned. That adjourned it to 21st May formation.
Yes, it has lost position, and we cannot adjourn it seeing that. That's why we are asking for a date, because we are interested in that application.
I just want clarification. Does it mean that the pre-trial handling of this case in this court continues after the commitment that you have just made?
That application has been given a date. The lawyers can follow up on that date. For now, it's been committed to High Court.
Josh, before you check this, we need people to record for having supplied the test with the copy of the indictment.
We had given you a copy of the election. It was on record. We had given the defense lawyer but I'm going to let me produce the copies.